easiest to do. So yeah, so that's what without further ado, we'll move on to the presentations, because as I said, we have a really fantastic lineup of speakers today. So joining us today to talk on this issue, we have Brian Chen, who's a staff attorney at the National Employment Law Project. Following him will be Ken Jacobs, who's the chair of the UC Berkeley Labor Center. After Ken is Meera Joshi, who's the former commissioner of the New York City Taxi Commission. After Meera is Hayes Witt. He's the CEO and co-founder of Driver's Seat Cooperative, and he's going to tell you more about that. And rounding things out is Saba Wahid, who is the research director at the UCLA Labor Center. So without further ado, I'm going to turn things over to Brian to kick us off.
Thanks so much, Dave. Hi, everyone. I recognize several of you, but for those I don't know, my name is Brian Chen. I'm an attorney at NELP, and a lot of my work in the past year and going forward has been related to California Proposition 22. And I am, this audience is a pretty smart and sophisticated audience. I know you're all familiar with Proposition 22, so I will just give a little background briefly. So in California, Assembly Bill 5 is a state law that was building off a California Supreme Court case, and AB 5, Assembly Bill 5, expanded access to employee rights in the state, things like wage and hour protections, unemployment, state disability, workers' comp. It expanded those protections via the so-called ABC test, and those protections were expanded to gig workers, app-based workers. And so the gig companies like Uber and DoorDash and Postmates immediately started to fight AB 5. They made arguments that it was unconstitutional. They made pretty ridiculous legal arguments that, oh, we're not actually in the business of providing transportation. These were arguments that were always laughable and were losing very quickly in courts. And they knew that they were losing in court, and they knew that they couldn't beat AB 5. And so they ultimately poured all their resources into this ballot initiative, Proposition 22. Contrary to what some of the reporting has been in the media, Proposition 22 does not overturn AB 5. AB 5 is still the law of the land in California. But what Proposition 22 does is it exempts app-based transportation and delivery workers, Uber, DoorDash, Instacart workers. It exempts those workers from being considered employees and receiving those state benefits, and it locks those workers into independent contractor status, and it guarantees them certain benefits, but benefits that are far less than what they otherwise might receive under state law. And I believe that Ken will get into some of those so-called benefits, but the companies really hammered this messaging that gig workers, especially during COVID, they're struggling, they need help, and here are some groundbreaking new benefits that we would like to provide. It was very deceptive messaging. They spent an incredible amount of money on it, upwards of $200 million, flooding the airwaves with advertising, in-app messages that likely were illegal under California state law. And Proposition 22, I should say, is not the start of the company's lobbying efforts. They have been doing this for a decade now, really, carving workers out of employee rights at state legislatures across the country. But what Proposition 22 does represent is a kind of new turn in their messaging and in the solutions that they are putting forward. It is essentially a kind of full compromise where the companies agree to grant some limited benefits while denying and foreclosing permanently full employee benefits. And it is essentially treating app-based workers as somehow less than other workers who don't receive work over through a digital app. And that is the new model going forward, it seems, from these companies, that they want to explore this third way classification where workers are given some benefits, but they have to give up and abandon their employee rights. And the really dangerous implication of this, of course, is that these gig companies, very wealthy corporations, can redefine what work is, what a worker looks like, and the kinds of protections that workers ought to receive. And we're going to see this at the federal level, certainly, and we're going to see it in other states as companies try to as the companies try to spread Proposition 22 like bills, whether through a ballot initiative or as a legislation in other states. And I think it's worth pointing out that however one feels about the question of should gig workers be employees, should they have certain standards, it is a real problem when companies that have an army of lobbyists and money can basically just decide the specific agreeable amounts of benefits that they would deign to give to their workers. And we as a community of worker advocates within the labor movement, I think we need to think about ways to fight back, to support worker organizing, and really to make the point to the public that these kinds of third way compromises, things like Proposition 22, they are anti-worker, they are not good for workers, they are not good for consumers, they are hearkening back to racist exclusions from the New Deal era and before. And I think we as a community need to explore state strategies, state-specific research that can support those organizing efforts and really help build worker power. I'll pass it back to you, Dave. Thanks. And happy to take any questions later.
Great, thanks so much, Brian. Thanks for sort of setting the scene for everyone. To start talking about some of that state level research, I'll turn things over to Ken Jacobs. Ken?
Thanks, Dave. So when Prop 22, when we first heard that this was looking like it was going to go on the ballot, we immediately went and started to do research to look at what does it mean? What were they actually guaranteeing that they would do? Because the ballot initiative said that people would be guaranteed 120% of the state minimum wage. And to understand what's behind the way they do this, first there's two key issues. The first is the question of time. And the big game that the companies play is they don't count roughly a third of drivers' time. They act as though that time does not exist. So the law and that their guaranteed wage pertains to what they call engaged time, which is the time in which a driver has accepted a ride and is on the way to get a passenger, or where a passenger is in the vehicle. They do not count P1, what they call P1, when the app is on and the driver's waiting for a ride. And of course, that is an essential part of the work. You cannot do this work without waiting between rides. And when people wait, especially if they're in an urban area, they're often driving during that time, which also is vehicle expenses. So one of the things we had to look at was how much time is spent in waiting time and how many miles are in waiting time. And this is data which some of you may find useful from Fair and Peers, called what are TNC's share of vehicle miles traveled. And they come out with an average, but they have some different cities that you can draw from, about a third of miles driven being during that waiting time. California, we had some better data from the California Air Resources Board, and there we came out as about 28% of miles. And I did some other calculations that came out. We think it's about a third of the time. You would assume it's a little more of the time than of the miles. So again, that is time that is not being counted in any of their calculations, which is important because it also plays into when they say how much drivers currently earn per hour. Some of the kinds of estimates that some of the academics that they pay put in also exclude that time, or parts of that time. The second piece is expenses. And the claims that the company makes is generally that expenses are only around 20 cents a mile. I guess they did it a little bit higher in the ballot initiative than that. But the way they get there is in operating costs. The IRS or AAA would count all operating costs, fuel, maintenance, and repair. And Uber and Lyft consider most of that, but not all of it. But the key piece is in an ownership cost, they don't consider insurance or time depreciation or finance charge. That is the costs of buying a vehicle. or yeah, the finance cost of buying the vehicle. And their argument for not including time depreciation or all of the operating expenses or insurance is they claim they say the most drivers only work a small number of hours and only work for over a short period of time. And that's true if you're looking at most drivers. It's not true if you're looking at who does most of the work. And this is the bait and switch that always goes on here. If you look at who does most of the work, those are people who are working at least 20 hours or more a week, and for whom the vehicle is used for most of the miles going on the vehicle are used in that work versus for their personal use. So then we get into analyzing their ballot initiative. And what we looked at was they said, okay, they're going to pay this 120% of the state minimum wage, but only for engaged time. So we looked at that and say, okay, if they're not paying for waiting time, that's $5.15. That's worth about $5.15 an hour that they're not paying for. And then they're not paying for the expenses during waiting time. They're not paying for any of those waiting miles. So if we take the estimate number of miles during that time and multiply by 57.5 cents a mile, we get to $3.83 a mile. Then for the rest of the miles, if we factor in their underpayment of driver expenses, that knocks off another $1. And then, of course, if we're comparing a wage to what you get if you're classified as an independent contractor, you don't get the employer share of payroll benefits. So we factor that in to get a wage equivalent. And then the final thing is, and here we're being overly generous, they also have a healthcare stipend. But the key thing is you can get that stipend if you work at least 15 hours a week for an entire quarter. But that's also engaged time. So that's really 22.5 hours per week, but you have to do it for the entire quarter. And then if you work 40 hours a week for the entire quarter, or I guess it's 30, but 45 with engaged time, you can get twice that amount. It'll never happen. I mean, very, very few people will ever reach that threshold. If you miss any time, you're sick, et cetera, you won't get it. But we credited them the $1.22 an hour, which we thought it was worth for a driver working 30 hours a week. And that just gets us to $5.64 an hour. So while Uber and Lyft were claiming that people would earn 120% of the minimum wage, the actual wage equivalent was about a third of that. And what's important here is, they spent, of course, $200 million on the campaign. And that meant in the end, I think it was over 40% of the people who voted for them, according to one poll, thought they were improving and raising labor standards for rideshare drivers. So by phrasing this as we're going to pay people 120% of the minimum wage, they succeeded in and start paying mileage reimbursement. They succeeded in confusing lots of people, but it was important in the campaign to get out, and we did this very quickly. This is what for people to understand this, we wanted to make sure that people had the evidentiary basis was what it was really worth. The other thing that was important for drivers was just to go over, because at that time, the company still had not complied with the California Supreme Court ruling or AB 5, was what would drivers earn per hour if they were paid as employees? And here we did the basic, what's the minimum wage? That was a weighted average for the state, kind of an odd way to do it, but we needed the calculation for other purposes. What are the legislated benefits on top of that? And then the expense reimbursement at averaging 22 miles an hour, which is what we got from the California Resources Board, to show that people would earn about $31 an hour gross if they were treated as employees. And that's about a 36% pay increase. Finally, one of the other papers we did, I'll talk about another piece. This is all research I did with Michael Reich, my colleague Michael Reich to the Center for Wage and Employment Dynamics. And we estimated that over a 5-year period, had the companies been paying into unemployment insurance, it would have been about $417 million. And that was an important part of this debate about what they weren't providing the drivers in the state of California. And we did this because California has a very low UI base. So we just needed to estimate of the distribution of the drivers, how many earned more or less than $7,000 a year, assumed that those earning less, well, we knew anybody who earning more, it was just at 7,000. We just assumed whoever earned less was in the, was at the median. And so we had some good data, decent data from the California Air Resources Board on the number of drivers that allowed us to figure this out. And this got also a decent amount of play in the media. And just to say the last piece, and I can answer questions about how we did that. It's going to be harder in some states where we have less data to rely on. But the last thing that we did, we spent a lot of time also trying to debunk studies that were being put out by the companies. And with that amount of money, they were able to get researchers to write report. Their own researchers put some stuff out, and then they got some academics to validate things that were absolutely insane. I know I'm running on time here, just say that one of the key ones was a claim that 80% of drivers would lose their jobs, or maybe it was even higher. And the calculation they did was, if workers are employees, and then we would have to hire everyone as full-time workers, take the number of hours divided between full-time workers rather than part-time workers, and you have fewer employees. Of course, everybody on this call knows there's nothing in law that requires people be hired 40 hours a week, and it's insane for this work to think they would be, but that's the kind of stuff they were putting out and confusing lots of reporters and lots of people. Reporters are also people, lots of other people as well. So there was a lot of whack-a-mole with just things that, you know, they would put out that we'd have to, you know, that we would dig into to try to figure out what it was that they were saying. So happy to answer questions in the discussion.
Great, thanks, Ken. So now we're going to turn to someone who has helped provide some improved working conditions through government policy firsthand, and she's going to tell us about that and her thoughts on this fight, and that's Meera Joshi. Meera?
Hi, thank you everybody for joining, and thank you for your interest in this topic. So I'm going to talk a little bit about the New York City experience. It predates Prop-22, and I think the New York experience tells the story of how you look at driver wages and driver earnings and try to create standards, but not from a company perspective, but from a government perspective. So in New York City, we weren't faced with AB 5 and a decision about employer-employee or not. I ran an agency that set the licensing and operation standards for over 150,000 drivers and about probably the equivalent in vehicles. And what we were faced with was an outpouring of anecdotes from drivers about how their incomes were going down and down. This was around 2017. At the same time, Uber and Lyft were continuously cutting the passenger fares, first to be at the same level of yellow taxis and then to be 25% lower than the level of taxis. And each time they lowered the fares, I'd get a call and say, we're lowering the fares, but the good news is passenger demand is going to go up. So drivers will be earning more than ever now because they'll have even more trips. But unlike their promises, the reality was they were also aggressively recruiting new drivers. So driver earnings did not go up. The number of trips went up, but the pool of drivers was growing by 1,000 a week. And so the trips were spread over more and more drivers and less of an ability to earn. And when you did earn, you were getting paid at lower and lower rates. I bring this up because it's to one important point that I think we have to keep front and center when you look at sort of Prop 22 and other company solutions. The bottom line for the companies is they want quick response time. You get quick response time by having lots of idle drivers in the vicinity of a paying passenger. And so they don't so much care how busy a particular driver is. They do care that there are lots of idle drivers in the nearby vicinity. And you can see how obviously the incentives of drivers and the incentives of companies are completely unaligned in that scenario. So faced with this anecdote, we felt compelled to move forward on standards for drivers around payment. We had a history of doing that for taxi drivers. And so using existing regulation, we wanted to do the same for the Uber and Lyft drivers. We knew we cannot, and I don't advise anyone to, and I think I'm probably preaching to the choir on this one, make any kind of regulation based on anecdote. It has to be based on actual information. So we required the companies to provide us with 1 week of pay data for representative of each season, because driving is a seasonal occupation. If it's the dead of winter and January, it's a little slower, but April and May are pretty busy months. So you need to have a good cross section. And with that information, we studied to look at benchmark what the current conditions were. And that information included the time, the length of the trips, the times of the trips, how much drivers were paid for each trip. And it showed us the time between trips. And it showed us the bird's eye view of drivers' earnings when they worked for multiple apps. Half of them ended up, a good portion of them either worked all for Uber or all for Lyft, and then some subsection worked for Uber and Lyft. But what that data showed that was incredibly important is that 96% of drivers were making less than the city's minimum wage. I'm going to jump ahead real quick just to show you that New York's not an anomaly. Seattle recently undertook a similar study, and their findings were very similar. I think it's the high 80%, if not 90% of their drivers are making less than the Seattle minimum wage. So looking at the actual data, you find that the current state of affairs is pretty stark. Chicago is embarking on something similar, and I wouldn't be surprised if they find the same to be true. With that information, we came up with a formula that would guarantee a certain minimum amount per mile and per minute benchmarked to the minimum standard of the New York City minimum wage. And we also added in a factor called utilization to take into account the fact that the companies themselves have no incentive to keep a driver busy. That once the driver's out on the road, they don't, the drivers want to make sure they're earning every hour, but the companies don't necessarily care. So not only after the policy was passed, what was set was a minimum amount that they must be paid per mile, a minimum amount that they must be paid per minute. And that mile and minute goes up or down depending on how well utilized drivers are. So if they are not utilizing drivers, they're going to have to pay them more per minute and per mile. And if they are utilizing drivers well, they could actually pay them a little less per minute and per mile. The upshot is that drivers come out the same because they're still earning. And again, this is to be a minimum. This is not meant to be the ceiling, it's meant to be the floor. There are many nuances on ways companies try to argue that it should be changed so it should become the floor, but we pushed back on all of those and we're successful. I want to be mindful of time, and I know people have questions, so I want to jump ahead real quick to, obviously there was litigation. Lyft sued on this, especially on the utilization point, arguing that if they were competing against Uber on keeping drivers busy, Uber would always win, and we were in fact handing over a monopoly to Uber. The lower court dismissed the claim. They appealed, and the appeals court has likewise dismissed the claim only just 2 weeks ago, finding that there's a rational basis for that requirement. And the other good news from the passenger point of view is these companies can be very efficient when they want to or if they're forced to. So they're extremely good at pricing, to customize surge pricing and to make sure that drivers are where there are high demand areas. Likewise, when we force the utilization factor onto the companies, they actually managed to reduce wait times for passengers in New York City and still keep drivers busy. So there are possibilities, and they do have incredibly smart people working there. And so I encourage people not to be, I would say, put off by the fact that something is complex. That this is a complex area, requires complex legislation and complex regulation, and the companies are well equipped to deal with it and can actually do a good job when mandated. I do caveat that if not mandated, they will not. And I'd like to pass it back to you and welcome your questions at the end of the presentation.
Thanks so much, Mira. That was really helpful. So we're going to turn things over now to someone who has been also working on the driver side of things to try and give a voice to drivers in this discussion, in this fight, and that's Hayes Witt at Driver's Seat. Hayes.
Hi, folks. Really excited to be here with you. I'm a former organizer and urban policy guy, most recently at the Partnership for Working Families, and see a lot of familiar names on this call, and glad to be here with you. I'm going to try to share my screen here, so I could use it to talk to you about Driver's Seat. So are you guys seeing this title slide? Great. So Driver's Seat is a driver-owned cooperative that empowers gig workers, specifically rideshare drivers and delivery workers, to capture and make use of their own work data. And my partner, who's also a former organizer and campaigner and now data scientist, started Driver's Seat after hearing from hundreds of ride-hail drivers that they were experiencing data and algorithmic management as a lever of power in their work. And it was one that they didn't have access to and wanted badly to have access to. At the same time, we were watching the work that Mira was doing in New York, which is really kind of an inspiration for this whole project, and work that Michael Reich has done along with Ken and Michael Parrott, and really hearing from city planners across the country that their efforts to shape the gig economy for a broader set of public good were stymied by a lack of access to data. And so the opportunity that we saw was to empower drivers to collect the data themselves. Through their labor, they're generating the data that is at the root of all of these different kinds of analyses and regulatory schemes and business operations. And so what we do is give workers a way to collect it themselves and share it with people they want to share it with. At a nuts and bolts level, we have a mobile app that a ride-hail driver or a delivery worker can use to collect their earnings data, to collect their mileage, and a whole sort of host of travel data. We aggregate that, we give them back insights that help them earn more money and manage their time. And then we also sell that aggregate data to public agencies who are trying to figure out how to shape the gig economy. And finally, we partner with gig worker organizations and public interest organizations who want to use our technology for research projects. And I think there's two main points I want to share with you all today as you're thinking about your work in a post-Prop-22 environment. One is to think about driver source data as a way to see the world, present the world through a driver's eyes. So Mira and Ken have already talked extensively about kind of the full spectrum of time, earnings, and expenses that needs to be captured. At least half of the gig workers that we talk to work on multiple platforms. So for a gig worker, the job isn't just Uber or isn't just DoorDash. The job is, I am a delivery person and or a ride-hail person working on these multiple platforms. And as we think about what future-looking policy should look like, we need to consider that. Likewise, to capture kind of the wide variety of worker experiences, as Ken talked about, some folks are part-time, some folks are full-time, some folks have been at it for a long time, some folks are just getting started, and capturing all that information is crucial to making good policy. And then finally, this is such a dynamic environment. It's changing all the time, and so having ways to monitor the impact of different business and economic and regulatory changes is a crucial part of making this work. And I want to show you just sort of what this looks like in terms of the real data. This is a sample from one ride-hail driver in Portland who used driver's seat to track her earnings. And what she saw over time was that where she had perceived that she was making $22 an hour, you know, on a bad day, $12 an hour, when you netted out her expenses, it was, you know, a good day was $820, a bad day was $460. This zero is an outlier, but this, you know, $280. And so this gave her kind of a real world view that she was able to use to decide how she wanted to keep engaging with this platform. And this data can be aggregated upward into policy debates and narrative. This is a sample from delivery drivers in San Francisco. And you see two things here. One is that their average net wage was $2 an hour under San Francisco's minimum wage. The other thing you see is just incredible variability here. And so I think as we're thinking about what is the right policy to advocate for and how to communicate about that, being able to see this kind of data at the aggregate level is a crucial piece. And then finally, we talked a little bit about the sort of distribution across platforms. The data that we collect is sort of assigned or tagged to a platform. And so with it, we're able to show each platform's kind of allocation of responsibility, but then looking at it through the other lens, how it looks for a driver who's working on multiple platforms and where they're getting their income, where they're spending their time. The second big point that I want to make today is that there's a real opportunity to use driver source data and other sources of data to connect workforce issues to a broader set of community concerns and build a broader constituency for shaping gig platforms in a more responsive direction to a broader set of stakeholders. And it's three kind of key areas. One is transportation. I'm going to go through these in detail with some slides in a minute, but transportation, small business disruption, and food access are all kind of issues that folks in the broader public interest sphere are concerned with that are directly impacted by gig economy issues, and where sourcing driver data can help make connections between the needs of drivers and the needs of a broader set of community. Here's some examples. So this is one ride-hail driver in San Francisco who tracked their work with driver seat over a week. And what they saw is that their efficiency in the East Bay was much lower than their efficiency in downtown San Francisco. And so their effective hourly wage is these green bars, is much lower in East Bay. And so what this shows is that drivers are incentivized to be serving downtown San Francisco and disincentivized to be serving East Bay. And as folks are thinking about how do we put boundaries around the gig economy to ensure that all communities are served equally, this kind of dynamic needs to be surfaced and addressed. This slide shows the relationship between productive, which is kind of the active time that Ken was talking about, and deadhead time mapped onto a geographic area. And there's a couple interesting things about this. One is deadhead time is time a driver's not getting paid. Ken and Mira talked about that. But from a transportation planner's perspective, this is all congestion and greenhouse gas emissions that is totally unnecessary, is like serving no productive purpose, and that our city leaders are charged with reducing. You'll also note that the burden of the deadhead miles is not distributed equally, and that the East Bay has a higher deadhead mile burden than San Francisco. So again, this kind of data collection and this kind of data analysis can be used to build kind of policy bridges and coalitions between different sets of stakeholders in these gig economy debates. One more example is as cities consider what's the right way to price access to our public infrastructure, our taxpayer-funded public infrastructure, and consider different kinds of TNC taxes or delivery fees, cities are weighing kind of what's the right formula. And using really granular driver-generated data, we can do an analysis that compares what's the revenue look like if you tax per vehicle mile traveled in the financial district, per trip that ends in the financial district, or per trip that starts in the financial district, and model different scenarios for that. So again, another opportunity to sort of tie driver issues to a broader set of issues that are, that are hot in our world today. I think I'll stop there, and my contact info is there, and I know we're going to have some good question and discussion time at the end of this. But super excited to share this with you all and to hear from you all kind of where you're looking at connecting with drivers around generating data for the kinds of research that you're doing.
Great, thanks, Hayes. And so to finish the formal part of the presentation, we have someone who has been doing a lot of thinking about ways, policy options to improve conditions for platform workers, and that's Saba Wahid. Saba?
Thanks, Dave. Hi, everybody. So great to be here. And those were great presentations to follow. I am going to set up with my screen share. So give me just 1 second. Good. You can see it. All right. So yeah, so I'm going to talk about directions for policy making. This is based on a report that we did here at the UCLA Labor Center last year, where we surveyed 300 gig workers throughout the state and conducted 15 interviews, with the caveat that we ended up with a lot of ride-hail drivers and more surveys from Southern California in terms of some of the limitations. But the idea behind this research was actually based on a proposal by SCIU UHW, which was, what if we created kind of a worker-owned structure to respond to how gig workers could relate to workers in an AB5 world, and basically kind of proposing a worker-owned business model, which they called the Cooperative Economy Act. And the idea was basically that there would be something called a cooperative labor contractor, which was basically a staffing firm to employ workers that would be owned and governed, but that middle agency would actually be owned and governed by workers themselves. That was pre-Prop-22. The surveys were done earlier in the year, and it really was to see if drivers and workers found this to be an outlet that they would actually see as a way to address their conditions. I'm not going to push for, I'm not here to talk about the CLC in the sense of like that as the policy solution, but more when we had these conversations with the drivers, what did they tell us about their work conditions that they wanted addressed in a structure like the CLC? So that is actually what I'm going to share. It's in the context of the CLC, but how can we use some of those findings to think about policies that we're thinking about moving forward with in a post Prop-22 and in a Prop-22 world. But first, because COVID, we were actually about to do in-person listening sessions throughout California. COVID happened. We completely revamped the project, turned it into surveys and online surveys and interviews, and added a bunch of questions to ask how workers were doing during COVID. And just quickly, we saw many of them had stopped working. They saw reduced hours. weren't getting PPE from the companies. If they bought it themselves, they weren't getting reimbursed, lack of communication around health and safety concerns, not feeling like the companies were doing enough to protect them from COVID-19. And then, like we heard from Ken, they were applying for unemployment and PUA and experiencing pretty severe economic hardships, and from not being able to pay household expenses to food insecurity and housing insecurity. So when it actually came down to thinking about the work conditions and ways to address them, the income and wages is probably the most obvious. I feel like the data from Hayes and the stuff that Mira and Ken were both talking about, it's, the first thing you want to get addressed is the wages and the earnings. And, all the stuff that I know folks on this call are probably familiar with in terms of, the constant changes in the way that they're in the kinds of wages and fares that they receive, whether it's the commission fees, the bonuses, the incentives, the lack of transparency, the instability of the wages, all of that, first, let's go to the wages. And that came up over and over throughout the surveys and interviews. Thinking specifically about the CLC, like when negotiating kind of terms with the companies, very concerned about any kind of wage exemption or removing liability from the companies for their work conditions. So it was interesting because a lot of them were talking about there's not a one size fits all that can be applied to the minimum, that can approach like a minimum wage that can be applied to the work. And I think some of the things that we heard about in the earlier presentation in terms of, they were talking about kind of this, what we're now calling engaged time versus like the real time spent working. So concerns about that in the way that a minimum wage would be calculated. Many of the grocery and courier workers were also wondering, can we think about the type of work and some of the demands of the work that are also, beyond mileage, whether it's heavy items or climbing stairs or going up hills, accounting, of course, for the operating cost. I think the $31 that Ken was talking about, or, something that really accounts for the full cost of the work. And then also looking at declining work as an income consideration, because a lot of times that decision happens because of, the financial impact of not taking that job. And then in terms of hours, most of the drivers and workers actually talked about, the trade-off of flexibility for a reliable schedule and having some guaranteed benefits. But then there was a lot of concern about scheduling limitations. And I think a lot of folks on this call have worked on Fair Work Week and scheduling practices like in the retail world. And I think some of those warnings can also be applied here. For one set of workers, it was a concern about minimum working hour requirements. For another set of workers, they were concerned about maximum hour limits, particularly if it was like, let's distribute wages across workers, which means, everybody works a little bit less so that everybody gets more work. There was an Amazon Flex driver that actually talked about how in his hours allotment that there was actually a cap that prevented him from getting full-time work. And so, that was definitely thinking about some of the, ways that retail or restaurants, some of the other service sectors would also limit the amount of work to keep workers out of that full-time category. And I think this came up also in some of the earlier presentations around the different conditions that and priorities if you're full-time, part-time, or a casual worker. And, they talked about it in the context of, well, how does decision-making work? Does the casual worker have the same amount of power as, say, someone who works 40 hours? But I think that the fact that there are different sets of workers who come at the work with different sets of priorities and how to balance that as we're thinking about policy making. And then in terms of structures and support, they did talk about prioritizing long-term negotiating power over short-term profit sharing. How could we build institutions, again, thinking about CLCs for this group, but just maybe thinking about that more broadly, that can counterbalance corporate campaigns. So could there be a way, they gave the example of like, well, if there was a federation of all the CLCs, and could they actually become a lobbying arm? And then, what could be ways to build more worker-centered ways of providing resources and tools? So, how can workers be in a position to be able to plan and, finance and purchase or rent their own vehicles versus having to go through these companies? What could be some financial and legal resources, like credit unions or pension funding that could be built, on a worker side, childcare services, education opportunities. And then in specifically to the CLC model, we don't want just another middleman. And of course, there was this kind of thing is like, why can't workers just own their platforms outright? Which would always be kind of like a broader long-term goal. I think these are also probably very familiar for folks, the one-sided relationship with companies, the lack of appeals, the unilateral termination, and, again, how can those things, and, how much does Prop 22 even address that? But that the continual customer is always right, and workers feeling really disempowered in the app's, kind of management system. Could there also be customer rating systems that mirror the rating systems for work? Again, the penalties around work refusal based on negative ratings or reducing their workloads, addressing safety concerns, and then just overall how to make gig work more sustainable. And then in terms of the algorithms, again, probably familiar, but workers describe their experience as unpredictable, mysterious, and often manipulative. I feel like Hayes's tool would really address that. It was really amazing to see that data. One worker described like trying to, figure out the algorithm and, called it a trial by algorithm. Even if there were systems where workers could be contracting, with this kind of middle person that would have a little bit more power, just still this control of like having control over the technology that enables the work. And, even if something like a CLC were to exist, would it just become a race to the bottom? That we're just continually going into a race of the bottom that's already rampant in the gig work. So how are there ways to create some baseline measures collectively? How can we have structures that just don't reinforce existing imbalances or allow companies to basically say like, we've got this structure here now, so we can go back to just saying we're a software company. So kind of finally, just to conclude, we did some kind of very like broad analysis of some other kind of cooperative structures. And I just pulled out a few pieces that I felt like echoed some of the things that the drivers said. So the very famous, Spanish Mondragon Corporation, European Mondragon Corporation. There's a lot of components about how you could measure some of the successes there, but also the fact that they had like this robust suite of financial resources and education and training programs for all of its workers. The Cooperative Home Care Association, which really prioritized benefits even over kind of like the dividends that cooperative members got, and then on the kind of more warning parts like the LA taxi system, where the cooperative structure here really had, what one driver actually called a cooperative in name only, that basically just had these kind of management structures. And I think the other thing about the LA taxis was like a two-tiered system where you did have owner drivers versus lease drivers, different priorities and different ways of, different parts of governance and decision making. And then contracting models where, like, you know, you create a middleman that actually shields the companies from responsibility and regulations. And you can see that in the farm work as well as garment work. And then those definitely create like really low road models of work conditions. So that's it for me. Those were some examples and some directions from drivers. And I will pass it back to Dave to start the Q&A.
Great, thank you so much, Saba. All right, so we'll move into the Q&A. As I said at the start, folks are welcome to submit questions via the chat, or you can use the raise your hand function and we can call on you and you can turn yourself off mute and pose your question to the presenters verbally. I'll go ahead and just get things started while folks input their questions. And I guess I'll start with, okay, actually Sasha poses a good one. So let's go with that. Sasha asks, is there any data or research on the impact of the TLC pay standard?
A very timely question, because recently, my mistake for not mentioning Michael Reich and James Parrott of the New School, Michael Reich of Berkeley, that did an incredible amount of work on the data that we collected, studying it, reviewing our policy proposals, giving us great criticism and helping us fine tune it for the final rules. They did a follow-up study on the impacts, and that study is available. I don't know, Ken, if you have the link to it handy. I don't have the link to it handy, but I'll get it and make sure I give it to Dave. And it showed that there was an increase in earnings, and it shows a lot of things, but I'm going to highlight these two. An increase in earnings, so the experiment worked, and a decrease in wait time. There was also an increase, not dramatic, but there was certainly an increase in the cost to passengers, which companies had said, as you hear them say in context with Seattle, who's recently passed pay protection, they're going to have to increase the cost to passengers. That did happen, but it wasn't clear that that was linked to New York, because similar increases in passenger fares were seen in Chicago as well, where no pay standard was in effect. And if you listen, they're saying they're going to do the same thing in California because of their own pay standard that they had passed. So there may also be some catching up. They're a public company now, and they did many, many years of pricing without reference to profit, and now they have to be more conscious. So it's hard to say that that's a function of the pay standard. But the bottom line is wait times went down and income went up. And I think Ken may have just shared the link. So thank you, Ken.
Thanks, Mira. Thanks, Ken. So I'll pose a question to the group, and this is just in some ways, I think I know the answer to this, but I just want to confirm it. I think there is some debate about the best policy response. I think a lot of us would argue that that platform workers should just be treated as regular employees, as they would have been, or they should be in California. And one of the arguments that the companies make is that if they had to do that, that the drivers or the platform workers would lose flexibility. There's no reason why someone who is a full-time employee couldn't just sign on and work when they wanted to under existing law. Is that right? And I guess I'll put that to Brian or anyone else who wants to jump in on that. They don't have to lose flexibility. Is that right?
Yeah, I think that's absolutely right, Dave. As people probably know, I mean, there is nothing in the laws around employee status that says that one has to lose flexibility, right? What we've seen in countless states, and certainly in the Proposition 22 fight, is that the gig companies want to weaponize that threat. They want to say, look, like if this flexibility that you love, you're going to lose it if you're granted employee status. Don't you love that flexibility? And one, a lot of drivers say that you know, the working conditions that they really have is not so flexible in reality. But that the other side of it is that it really is just a threat by the companies that if we are made to, you know, provide certain employee benefits, that we're necessarily going to have to withdraw that flexibility. And we should call it out for what it is, right? It is a company threat, and not a natural consequence of reclassification.
Michael Wright makes a wonderful argument on about the flexibility based on their research in New York, because he pointed out that the new pay standard wasn't binding during peak times. But where it was binding, and that's, you know, we saw from Hayes data that there are times and places where you can afford to drive. By having a higher pay standard across the board, it actually gives drivers more flexibility in that they could earn money in different places and at different times. So one can make that argument in both directions. But getting back to Amanda's question on strategy, I think the way I think about this is the goal should be to get people to get employee status, you know, at the federal level, at the state level where that's possible. And in the meantime, the kinds of things like Mira talked about in New York that are on a city level that are neutral on employee status but raise pay are useful places to go and can be done without undermining the idea of getting to employee status in the end.
I would add one thing on strategy. I think a lot of jurisdictions are being pummeled with Prop 22 like legislation, and a lot of lawmakers aren't quite sure what to, like, where to turn or how to answer that question. There is a path forward that I think supports employee status, also and supports clarity of what the current work conditions are, and that is ensuring that a locality, whether it's state or local or even at the federal level, that there's access to data, either existing regulatory power is used to get that data, or there is the response to what should we do on Prop 22 can be, we need to have data about what the current conditions are, and once we get that data, we'll make a decision. I think it's prudent, I think it's wise, and I think it's also more widely accepted, and I think it's a much more powerful sort of pushback to Prop 22, because it takes away some of the arguments that the companies will put forward, which is, if you don't do what we ask you to do, workers are going to lose flexibility. And in response, you're saying, well, let's actually examine that. Let's see where the workers are working, when they're working, what are their down hours, how much is it costing them to work, how many are working from multiple apps, and what is their pay when you benchmark it to minimum wage today. The results of that, as you saw in New York and in Seattle, are pretty powerful. And then it gives you a platform to fight for employer-employee, because it's clear that you have a large workforce that's making very little money.
Thanks, Mira, and Brian and Ken as well. I'll pose a question that we got via email, and I'm going to tweak it a little bit. So the person's asking, you know, basically are there research gaps, or what? And maybe the way I'll reframe it is, you know, if you look at what happened in California with Prop 22, it sounds like, you know, it was just an overwhelming swarm of misinformation that confused folks that kind of led to the ultimate passage of the proposition. But if you were to think about what really resonated or what could resonate in other states that might be replicable in other states, or that could be generated in other states to push back on these sorts of campaigns, are there things that come to mind as sort of the low-hanging fruit or the key pieces of information that you think need to be gotten out to the public? Or do you think it needs to start with this sort of data gathering transparency effort that Mira's describing?
I mean, one thing I want to say initially is I feel like part of the problem in California was not necessarily a messaging one, but the size of the megaphone. you know, so like it was really hard to counter those messages when, like, I mean, they were on the ethnic television, like every single language, Arabic, Hindi, you know, like all the foreign channels, they were on your phone app, you know, and I'm talking about the games. Like I used to get Prop-22 commercials on like the games, you know, in addition to the like the audience. So I do think that there is counter messaging, but to me, like if they're going to put the same kinds of resources that they put into California, how can you get louder than that? And yeah, and then thinking about some of the actual messaging that could counter, because I think the no on 22, the no on 22 did try to do a job to kind of clarify all the mixed messages and try to put forward what actually the terms were. And I think the research that came out about the $5.64 did get out there, but it just like, you know, even like progressive people were like, oh, wait, I was supposed to say no on that. So how to kind of counter that part?
And I just, thanks, Saba. I would just add that in states where they don't have the option to go to the ballot, I think you're in a different world. Because I think to the degree you're dealing with lawmakers and you've got more of an opportunity to get the voice heard. What was most important in California, and I think this gets to one of the points that Sage put in the chat, was that we had 4 driver organizations who were really out there getting their voices heard. And that's how AB 5 passed in the first place. The starting point on this, especially if you're dealing in a legislative fight, is having the drivers there and being clear on what they want and them providing that leadership. On the research side, I think the one thing that would have been useful, especially if you're in the realm of a legislative fight, that we did very late. Michael Reich and I, and it's one of the papers that I linked to, did some work looking at, okay, what would the effects be? Because they were coming out with these studies claiming that some huge share of drivers would lose work and prices would go up as much as 100% in certain jurisdictions and all the same kinds of things we hear during minimum wage fights. And I helped Michael on some of the research, and he got out a paper towards the very end. But I think something like that would have been useful to have earlier, to be able to really say, okay, based on research, you know, what are we really talking about in terms of price increases? And we figured out that it'd be pretty small. What are we really talking about in terms of change in hours? And it was clear that change in demand was so much smaller than the increase in pay. All of those things that we're used to from other wage fights. I think that would have been useful to have in a fight where you have a chance to get your voice heard, which is more in a legislative fight versus, I think, in a ballot initiative situation, as Saba said, it's just so difficult.
I want to also mention something that Saba hit upon, and I think is also in the chat. The fear of losing flexibility is very real and very powerful. But there's a distinction between how the companies portray this, you are going to lose flexibility, versus a driver's day-to-day experience. So I just want to make 2 points. One, where data can inform, you know, flexibility is a relative term. You can work when there is work. So it's not like you have ultimate flexibility ever. You can't hop in your car and expect to earn money at 2 o'clock on a Sunday, because there's not going to be the passenger demand out there. So you have some flexibility within limits, and those limits are, when is there passenger demand? That's going to be commuting times and high volume times, Friday, Thursday evening. So one, being careful about how you define what flexibility is, rather than it's sort of the way the companies describe it as this sort of utopia. You hop on the app whenever you want and the dollars just come rushing in, and they're going to take that away from you. And 2, the companies say you losing flexibility is a direct consequence of government action. And whether that is because AB5 passes and we can't have flexible employees, or it's because a pay standard passes and it requires us to keep you busy, there was a government action that resulted in us having to do this bad thing to you. And that's a fallacy. They're very sophisticated companies who have lots and lots of ability to do complex algorithms. They're able to master surge pricing. They're able to meet demand. They're able to meter up and meter down service on a dime. So they can use that similar expertise to figure out how to help drivers out, keep them busy, and keep them paid. There's nothing wrong with giving drivers paid time off. They could do that, right? There's nothing wrong with giving drivers, additional money to, pay on top to get them to certain areas, even though you're paying them less. They have the ability to think through some creative ways to minimize what it means to drivers when they adapt to policies like minimum pay. That they choose to take the cheapest way and the one that hurts the drivers the most is something that I don't think is out in the press that often. And it's something that's worth putting some time and energy into thinking how you communicate that. I'll give you, this is a very simple analogy and probably not a perfect one. I'm just hoping to sort of drive this point home. But in transportation, even in the taxi world, there was always if there's going to be something that costs money or has an effect, we want the government to have imposed that on us. So the taxi owners would always say, if we want our drivers to wear shirts, so you need to order them to do that, right? And so I think this feels very similar to me. Like Uber and Lyft are using government as a reason why they have to do things, force drivers or put drivers in awkward situations, when the regulation doesn't dictate that. The regulation dictates that they pay them decently. They're choosing to do it in a way that's actually hurtful to drivers.
I'll add, I think this is a really good discussion. I'll add that, there's a number of really good comments in the chat, and that a lot of workers do say that, I like the flexibility. I know that a traditional W-2 job schedule is something I don't like. I think this flexibility narrative really won't go away. It has to be addressed preemptively, even if, lawyers like us will say, oh, but the law is clear that that's not how it works. That narrative still is powerful. And I would point to one model that I think is promising, which that there is a bill in Congress. It's called the Worker Flexibility and Something Act. It was introduced by Senator Patty Murray. And in it essentially proposes to classify workers at the federal level under the ABC test as employees. But importantly, it does have a section that says any covered employee who is essentially reclassified shall have the same right to work flexibility in their scheduling, and that the companies cannot retaliate and kind of take away any flexibility that workers previously had. And I think that is an example of language that makes very clear to people. There's a legislative clarity of, this flexibility that workers like will not be withdrawn from them as a result of better pay and benefits.
Thanks, Brian. Thanks, Mira. Just scanning through the other questions. There's a lot of really rich questions. Sasha's asking about the difference between New York and California, and whether anyone has thoughts on the pros, cons of the two different strategies, or the ways to do both instead of either or around employment status.
I would just say on that, I don't know if Mira has something to add. I think the advantage of the fights in Seattle and New York was it sidestepped the question of employment status. And so it was very clear to everybody that this was about improving drivers' conditions. And on those terms, the companies lost in both cases. That said, that's why I think that doing this, the dual strategy of working at the local level to do those kinds of policies that are neutral, but would apply whether or not people were employees or independent contractors, while working to change the law at the state level to gain employment status is so important, because the latter means that people have access to those full rights and benefits and you avoid this erosion of work. And so, but it is a harder fight because of all the issues. And I think Sage raised this question, we all know low wage jobs, non-union jobs are crappy jobs. And, people, that's their experience in the world. And so there is this dual part, and the other part is organization and having a union so that people can make jobs good jobs, and recognition that employee status is essential, but is one piece of what has to be a bigger fight.
Well, that actually sounds like a great place to end the conversation, since we're coming up on 75 minutes anyway. I'll give the speakers one last opportunity to add any concluding thoughts if they have any.
I would just ask everyone who's in this space to stay curious. We're all being asked to make decisions about workers' livelihoods with very little information about the ramifications of those decisions, or what their standing is today with respect to what they earn. And I think it's really important information, and nobody should be asked to make those decisions without it.
Great, thanks, Mira.
What Mira said is so strong, and the one thing I would just add is that as we all explore ways to get more data on what's actually happening, that we ensure that sort of a cornerstone is that workers individually and as a group have rights to their own data, and that they're able to see it, use it, and get it in sort of meaningful and trustworthy ways, so that we can do that analysis, versus having it sort of segregated out to city staff or places where it's less transparent to all the folks who need it. And I think that's sort of like extending out on that point of getting the facts from workers to inform our thinking on this. It's really exciting to be thinking about this all with you all.
Great. Thanks, Hayes. Well, with that, why don't I just extend a huge thank you to all of the speakers. I really appreciate you sharing your time and expertise with all of us. To folks on the call, we'll be sharing the recording and the links in a follow-up email. Thank you for spending some of your afternoon or morning, whichever it is, with us. And feel free to reach out if you have questions. I can connect you with any of the speakers if you don't already have their contact information. So thanks very much, everyone. We'll see you soon.
Thank you.
Thanks, everyone. Thanks, Dave.
Thank you.